If you want to understand whether American institutions are still capable of stopping power when it pushes beyond its limits, this is the moment to pay attention. What unfolded today in Washington was not routine politics. It was not messaging. It was not theater. This was a full-scale system test under maximum strain, and the system moved first. Earlier today, a federal judge took an action without precedent in United States history. While a federal criminal trial was still actively underway, with testimony ongoing and evidence still being contested, that judge formally transmitted impeachment evidence directly to Congress. Not after the trial, not after a verdict, not after appeals. Right in the middle of the process. This was not a summary or an advisory opinion. It was the evidence itself, certified, indexed, and built under oath, delivered straight into the constitutional mechanism designed to remove a president. This did not happen during Watergate. It did not happen under Nixon. It did not happen during the Clinton years. Those were major crises, but institutions moved in sequence. Investigators investigated. Courts ruled, Congress debated. What happened today collapsed that order. The judiciary did not wait for politics to catch up. It intervened, and Washington responded immediately. Within hours, National Guard units were deployed around the Capitol. Security perimeters expanded, access points tightened. Members of Congress were moved into closed-door operational briefings. Not political briefings, operational ones. Institutions do not move this way unless they believe that delay itself has become dangerous. This was not treated as a partisan fight. It was treated as a constitutional stress event. And the chain reaction did not begin with the evidence reaching Congress. It began earlier, inside the same federal courtroom. Federal marshals physically removed the entire legal team representing Donald Trump. Not for disruption, not for defiance, not for procedural mistakes. They were removed for perjury. Under oath, that distinction matters. The court determined that sworn statements made by Trump's attorneys were knowingly false. That is not misconduct. That is criminal exposure. This is the moment where the story shifts from individual behavior to institutional response. Instead of pausing the trial or appointing new counsel, the judge escalated. The familiar presidential playbook, delay, stall, litigate endlessly, no longer applied. The clock changed hands. Judicial timelines behave differently from political ones. They compress time. They accelerate consequences. They do not wait for outrage cycles or public fatigue. When a federal court transmits impeachment evidence while a trial is still live, it sends a signal that cannot be ignored. The message was clear. The conduct before the court was so severe that normal separation of powers sequencing could no longer absorb the pressure. This was not activism. Judges are trained to avoid political gravity. They escalate only when they believe the integrity of the system itself is at risk. That line was crossed. And this was not the peak of the confrontation. It was the ignition. A critical window is now open, roughly 72 hours, not as a media trope, but as a structural reality, a period in which alliances fracture, additional evidence surfaces, and institutional pressure intensifies instead of fading. This moment did not create instability, it exposed it. Inside the courtroom, the escalation began quietly, with repeated warnings. The judge warned Trump's legal team clearly and on the record. Accuracy under oath was not optional. Denials would be tested against evidence already in the court's possession. Those denials continued. Under sworn testimony, Trump's attorneys repeatedly denied the existence of specific emails and records, flat denials, made 17 times under oath. The court already had the material, emails, metadata, financial records. Digital trails that do not forget. When confronted, the defense was given an opportunity to clarify or correct the record. They did not. That was the moment advocacy ended and exposure began. The judge ruled the conduct had crossed into criminal territory. Perjury is not a legal strategy, it is a felony. Federal marshals approached the defense table and escorted the attorneys out of the courtroom, in full view of cameras, the jury, and the public. This was not symbolic. It was procedural enforcement. Instead of restarting the trial, the court stopped everything and escalated again. At that point, the court concluded it was no longer dealing solely with perjury, but potential obstruction of justice connected to executive authority. The courtroom ceased to be just a trial venue. It became a trigger point for constitutional action. The judge issued a formal order stating that perjury and obstruction of justice constitute impeachable high crimes and misdemeanors, not in theory, but in direct connection to the conduct before the court. Then came the decisive phrase, "Congressional transmission is now complete." The court assembled and certified the full evidence package and transmitted it directly to the House Judiciary Committee. Transcripts, emails, financial records, recordings, and authenticated footage. These were not leaks. They were exhibits. Congress was ready. A previously dormant impeachment resolution already existed. Once the court-certified evidence arrived, support surged rapidly. Co-sponsors climbed past 220 members, a majority of the House. At that moment, impeachment stopped being speculation. It became arithmetic. President Trump responded with a rapid stream of social media posts attacking judges and Congress. This time, every statement was archived and treated as potential evidence. When Trump warned of civil war if removal proceeded, federal agencies shifted posture immediately. Security measures intensified. Intelligence monitoring increased. Contingency planning accelerated. Behind the scenes, multiple removal pathways are now moving at the same time. Impeachment, criminal investigations, and renewed discussion of the 25th Amendment. None of these mechanisms require presidential consent. This is no longer about rhetoric. It is about process. Judicial timelines do not pause for messaging. They do not bend to pressure. What is happening now is not simply a challenge to one presidency. It is a test of whether the rule of law still outruns power. This is a developing story, and I will continue to follow every update closely.